Okay, we are on the record in the matter of Jaeger versus Jaeger. Mr. Jaeger is present by Zoom. Counsel, state your appearance, please.
Your Honor, Benjamin B. Whiting, appearing on behalf of Mr. Carl Jaeger. Your Honor, before you is a signed proposed judgment of divorce and approved by a friend of the court. We have taken proofs in this matter, however, 21 days has elapsed, so we would like to redo the proofs, and then we would just respectfully ask the court to grant the divorce and sign the judgment and uniform child support order.
So, Mr. Jaeger, I apologize for mispronouncing your name. I should have guessed, given how they pronounce Jägermeister.
Yeah.
You raise your right hand, please.
Yes.
You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your full name for the record.
Full name is Carl Christian Jaeger.
Go ahead, Mr. Whiting.
Thank you, Your Honor. Mr. Jaeger, were the complaints and allegations contained in the complaint for divorce true at the time they were signed and filed?
Yes.
Are the allegations remaining true today?
Yes.
Are all the children that were born during this marriage listed in this proposed judgment of divorce?
Yes.
To the best of your knowledge, is your wife currently pregnant?
No.
Are you reasonably certain that this marriage cannot be preserved under the circumstances?
Yes.
You have signed the proposed judgment of divorce?
Yes.
Do you understand the terms of that proposed judgment of divorce?
Yes.
Have you voluntarily approved this judgment of divorce?
Yes.
And one final question, are you fully and completely satisfied with the representation provided by my office to you in this matter?
Yes.
Your Honor, I believe I've established a factual foundation to support entry of a judgment of divorce.
Mr. Jaeger, can you confirm to me that that is indeed Nicole Jaeger's signature that appears on the signature page of the judgment of divorce?
Yes.
I'm satisfied, based on the proofs, that there's been a breakdown in this marriage to the extent the objects of matrimony have been destroyed. There remains no reasonable likelihood the marriage can be preserved. I have signed your judgment of divorce and uniform support order. Mr. Whiting, I'm going to give those back to you along with the file.
Thank you, Your Honor.
You're welcome. You're all set, Mr. Jaeger.
Thank you.
Your Honor, have a good morning.
And you as well.
And a nice weekend. I think the weather's awesome.
Okay, this is a matter of Moore versus Moore. Mr. Donald Baranski is present for the plaintiff. It looks like,
I'm showing defendant.
oh, I'm sorry, for the defendant. Pardon me. And it looks like Mr. Moore is present in pro per. Mr. Moore, can you hear me?
Yes, sir.
Okay, this case is scheduled for a pretrial this morning. I have a note from Mr. Hotchkiss, who was appointed as LGAL. According to his memo, which I believe Mr. Moore and Mr. Baranski, you both received a copy of?
Yes, Your Honor.
I did not receive a copy of his decidings.
Well, he didn't really decide anything. He says he's not been able to complete his duties because he hasn't been able to connect with everyone.
Yes, sir. Nicole called me last night and said that she just wasn't going to move forward with it. She wasn't going to do it. She said she was done and she just wanted to sign the divorce. And then she implicated that she had spoke to Mr. Bransky and told him that she wanted to be done and just wanted to get it over with. So then he in return stated to her that he would write up a judgment of divorce, which is unnecessary because we've already done this. I already have a consent judgment of divorce that we've both agreed upon. I just need it signed. It's been forwarded to Mr. Bransky several times. I even took it to his office in person. He told me he'd be there till 5 o'clock. I showed up at 11. He was gone. So I left it with his secretary. At that point in time, she told me she did not need my consent judgment of divorce, that she already had it.
Someone else just showed up in my wait. Oh, never mind. It's for a 10 o'clock case. So, Mr. Baranski, where are we?
Well, Your Honor, to refresh your memory, what had happened was last pre-trial, Mr. Hotchkiss had not been notified. We were going to notify Mr. Hotchkiss, which was done. And Mr. Hotchkiss is correct. It's my understanding he did not have the opportunity to interview the parties. Mr. Moore is also correct that it appears to me that the only issue that was hanging out was the idea of what Mr. Moore's income was, because I needed to analyze that for assets and for potential alimony. After reviewing his interrogatories that he did send to me, by the way, I did talk to the mailman, and the mailman told me that he didn't know if anybody was in the offices, so he just didn't bother to try to deliver anything. So poor Mr. Moore had sent this all out to me back in June, and it just never got delivered because the mailman didn't know anybody was around. He sent certified mail. So I just want to clarify that Mr. Moore was correct when he said he did send the things when he did. After reviewing the interrogatory answers, Your Honor, it is our position that we can probably just go ahead and do a consent judgment. The issue with Mr. Moore's documentation is he did it in pro per, and as the court is well aware, there are certain statutory, state, and federal requirements that have to be in that judgment. So that's the only issue with what he prepared. So I think we can probably enter into a consent judgment, Your Honor. I don't see any need to have a trial. I think that's the only issue at hand would be those statutory requirements that the court's going to review and obviously would not sign if they're not in there. So that's all that we're talking about. So my paralegal indicated to Mr. Moore that she had a judgment. What she was talking about is she had one that had the requirements that are necessary. So I think that, quite honest, Your Honor, I think all we need to do is draft up a judgment and have the pro-con and have the court sign it. I think that's where we're at.
So, Mr. Moore, I just want to make sure you understand, the law does require that there be certain statutory provisions contained in a judgment of divorce. It sounds like from what Mr. Baranski has said, that the one you prepared is missing some of those essential provisions.
Okay.
So Mr. Baranski is fully capable of taking what you and Ms. Moore have agreed upon and incorporating that into a final consent judgment of divorce that has the terms the two of you agreed upon and has the required language that the court has to have in order to be able to enter the judgment, assuming it accurately reflects the provisions that you want to have in the judgment of divorce. That's something you would be willing to sign?
Yeah, I mean, as far as I'm aware, my judgment of divorce is correct in every way. If he has some corrections that need to be made, I would be more than willing to look at the corrections that he would prefer to be in the consent judgment of divorce. But the only thing that I was told was that needed to be changed was the fact that we had decided on a different school. All of the legal terms should be correct.
Yeah, the provisions about what your custody arrangement is, what the parenting time is, what school the child attends,
Yes, sir.
those
That's
aren't,
okay.
right, those aren't the kind of provisions I'm talking about. I'm talking about, there's some very specific language addressing the issue of spousal support and whether or not it's forever barred. There's language that talks about taking the child or children out of the country, and there's a few other
Yes, sir.
provisions.
That's all.
Uh,
That's all in there, Your Honor.
All right, well, in any event,
I've
here's what I'm going to
taken,
do.
I've taken extreme measures.
I
There's an internet.
didn't catch that.
I'm sorry. I'm sorry, I'm losing internet connection. I've taken extreme measures to make sure that this consent judgment of divorce was perfect.
I have no problem, Your Honor, just going through and sending whatever minor corrections are necessary to Mr. Moore, and you can put those in his judgment. I have no problem using his judgment with those minor corrections.
I appreciate that very much. My concern is that Nicole has been through quite a few jobs and trying very hard to get her life together at this moment. She has very little money. She's already exhausted almost all the money that I already gave her on Mr. Bransky. And I feel that I'm just trying to stop any more, from hurting her financially. She has two children
Right,
to
well,
take care of as
here's-
well as I.
Here's what I'm going to do. Mr. Moore, I'm going to take some basic proofs from you that will permit me to sign a consent judgment of divorce. If you guys get me a signed consent judgment of divorce on or before the scheduled trial date, I will sign it and there will be no need to appear. If you don't get it to me before that date and you haven't arranged for, if you need a little extra time, I'm fine with that. I'll expect you to be here on the scheduled trial date. So, Mr. Moore, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your full name for the record.
Jason Sean Moore.
Mr. Moore, you filed a complaint for divorce, it looks like back in December of last year. Was everything in that complaint for divorce true at the time that you signed it?
Yes, sir.
And is it still true today?
Yes, Your Honor.
According to a temporary order in place, I see that there is there are two living minor children born or adopted during your marriage to Ms. Moore. Andrew Moore, born October 26, 2004, and Olivia Moore, born July 15, 2015. Is that correct?
Yes, Your Honor.
Were there any other children born during this marriage that are not your children?
No, Your Honor.
To your knowledge, is Ms. Moore pregnant?
No, Your Honor.
Is there any possibility of the two of you reconciling?
No, sir.
You can put your hand down. I'm satisfied based on the proofs there's been a breakdown in the marriage. To the extent the objects of matrimony have been destroyed, there remains no reasonable likelihood that the marriage can be preserved. If I get that consent judgment of divorce on or before August 20, I will sign it. Otherwise, I'll expect to see you here for a trial. Thank you very much.
Thank you, sir. I appreciate your time.
Have a good day.
You do.
Well,
You want me to keep the trial date on or change it to a status?